Amanda, you still see people coming in?
Yeah, yeah. Let's kind of stopped. I think we
Okay.
can
Okay. All right. So I'll wait.
get started.
I'll give another. Yeah, I'm giving another minute.
Okay.
Okay, we'll get started. Good afternoon, everyone. I am Marwan Porter. I'm the chair of the small firm and solo practitioner division of the National Bar Association. Thank you for taking time out of your Tuesday to be here with us, and to gain some valuable knowledge from two of our members. I see a lot of names that I know. Obviously, our founder, Patricia Rozier. I see you on there, and many others. So thank you for being here with us today. One of the things that we've been doing over the past couple of years now is having these virtual Zoom, sim webinars, so that we can enlighten our members throughout the year, and not taking up too much time, but making sure that we stay connected and that we're providing information to our members. So today we have another great seminar for all of you, and it's dealing with family law, and specifically when you're going through divorces and changes in marital status, when you're 50 and above. So we have Chandra Holloway and Keisha Garner. They are going to be our speakers today, and they will be educating us on some of the things that we need to look out for when we have a client who is running into these type of situations, so that even if you don't practice family law, you have some level of insight and education on what's going on, and who to send those clients to, and how to help those clients. And if you're in the DC, Maryland, and Virginia area, please support Chandra and Keisha, and send them the business. They do family law, and I understand wills, trusts, and estates. One of the main things that I'm very adamant about, with our practice and our division rather, is collaborating with one another and referring cases to one another. And you probably have seen our NBA case, small firm case referral pipeline. Please be on the lookout. We're really promoting that. We want to empower our members, and we want to make sure we think about our members first when we have cases that you may need help on. So please look out for that. We are supplying resources, whether it's money, litigation support, experts. We have everything we need right within our groups. So please look out for that. So without further ado, I'm going to introduce to you virtually Chandra Holloway and Keisha Gardner, and they will take it from here. Thank you.
Oh, good afternoon. My name is Chandra Holloway. It is wonderful to see you all in your boxes. And I actually see my law school dean, Everett Bellamy, here. So thank you. And thank you all for joining us. I'm going to share my screen so you guys can see the presentation. Okay, can everyone see it? If someone will just shake their head so that, okay, awesome. So I practice only family law. My office is located in Silver Spring. I'm the managing partner of the Holloway and Norman Law Group. My partner does everything but family. And I practice in both Maryland and District of Columbia. I asked Keisha to join me, Ms. Garner, in this presentation today because in addition to doing family law, she also does estate planning. And there's a lot of overlap between family law issues and estate planning issues. And so we have put together a presentation for you today. Give me one moment. So give me one moment. Keisha, the slides are still showing, correct? Okay.
Yes.
Thank you. Okay, so starting with just some background information, when we thank Marwan and Pat Rozier for inviting us to present to the division, and when we were thinking about what topics were really relevant, this is a area that I'm seeing a lot, doing only family law issues, that is becoming a more critical part of my practice. And gray divorces tend to be a little bit more expensive and lengthier because of the years of the marriage. And so they have more assets and there are more issues that need to be addressed. And so we thought that this would be a topic because as we're seeing it more, you're likely to see it more, especially if you're doing a practice that involves both family law and estate planning or elder law. So the divorce rates among adults age 50 and older have risen sharply over the past 3 decades. From 1990 to 2019, the divorces in this age group increased by 36%. And so today, 40% of all divorces involve one of the spouses is age 50 or older. And 1 in every 3 divorces includes one spouse over the age of 50. So why are people over 50 getting divorced? And the major reason is because they're living longer and they want their life to be fulfilling, and they may feel that their relationship isn't fulfilling to them. The empty nest effect, you have partners that will feel that they've grown away from each other once the children have left the nest and they don't have as much in common anymore. Women's financial independence, working more, women have become more empowered, and so they have less reason to stay in marriages where they don't feel that they are satisfied. And infidelity, this statistic shocked me a little bit. Men's infidelity peaks when they're in their 70s and women's in their 50s. And then caregiving strain. 21% of men leave their wives who are ill, and only 3% of women leave husbands that are ill. So the unique, and those are the other statistics. And then so the unique challenges in these sorts of divorces is, as I said before, more assets, retirement accounts, more property, pensions are involved. These tend to be longer relationships, and so they're longer familial bonds and a social a group of, well, moving on. I can't get the words together there. And then there are adult children that tend to be involved, and then the financial impact. So women over 50 who go through a divorce, 45% of them will see a decline in their standard of living. Whereas for men, you'll only see a 21% of a decline in their standard of living. So the first thing to consider when you're looking at a divorce for people that have been married a long time is, when does the clock stop on property division? And this is going to be jurisdictional specific by statute generally in most states. So in some states, the property interest is going to accrue as long as the parties are married until the divorce is finalized. In other jurisdictions, that property accrual is going to stop when the parties separate. So, for example, I give you the language in 2 statutes, the 2 jurisdictions that I practice in. So in DC, the statute specifically says that one of the factors that's going to be considered when distributing and dividing property is whether the asset was acquired or the debt incurred after separation. That's a consideration. And what will tend to happen in those cases is If there was a separation, then whatever was acquired after separation will be seen as one of the spouse's separate property. Whereas in contrast, in Maryland, the statute doesn't provide for consideration of separation. Everything acquired during that marriage up until the time the parties divorce is on the table to be separated. And so this is something to be cognizant of when you have clients who may stop living together. And this is something that I've seen happen a few times with older clients. They just they just go their separate ways. They don't go to court. They don't actually file for divorce. They don't do a marital settlement agreement. And then one party will file. So I had a case a few years ago where my client was in her late 60s and retiring, going through the process that year. And her husband was in his 70s, and they hadn't lived together for over 18 years. And he filed because he knew that she was nearing retirement and he wanted an equitable interest in her retirement. And her position was, well, what do you mean? I've been paying into this, and saving for 18 years and he hasn't been here. Why in the world is he entitled to anything? And so obviously, we were able to argue that he may not be entitled to 50%, which is what he was considering, but an equitable division was still on the table. And that could have been avoided if they had entered a marital settlement agreement, even if they didn't file for divorce. If they had just said, you know what, we're not ready to file. I'm fine going my way, you go your way, but let's do an agreement that says that whatever we acquire post this separation, whatever you acquire is yours and what I acquire is mine. If that had been done, then they would have been in a very different circumstance. But in that case, it didn't happen. So things for you to consider for your clients is to encourage them, even if they're not ready to file for divorce, to enter the marital settlement agreement. If they live in two jurisdictions, I know a lot of us may live on the line and practice in multiple jurisdictions. And so our clients may have residency or spouses may live in two different states. Look at the benefit of filing in one jurisdiction over the other if it's advantageous to your case. And alimony. Alimony is a common issue that's going to come up in gray divorce cases because of generally the age of the parties and the years that they've been married. And so these factors are generally the same from state to state, and they're generally statutory, sometimes in common law from state to state, but they're going to pretty much be the same. Your state, if Maryland is now and DC are now no fault jurisdictions. So I have fault there because I know that in several states, fault is still a factor that courts consider in making spousal support awards. But so those factors are going to be on the table, and primary to our cases in the gray divorce context is going to be age, because age is going to be critical a consideration determining someone's employability. Can they get a job? Can they maintain their prior income levels? Do they have medical or mental health limitations that are going to impact their ability to work, their ability to re-enter the workforce? And so those are considerations of why age is such a critical point in determining what alimony is going to look like in cases for those that are 50 plus. So the question that everyone wants to know is, well, and I have clients ask me, how much should I be asking for? How much do I really need to live off of? And so when I'm doing divorce planning with clients, that's sort of the bread and butter issues that we deal with on the front end of, I will have a client tell me, so you want a divorce, and tell me, what does that look like on the other end? What are we trying to achieve? Where are you going to live? Where are you going to work? How are you going to pay your bills? And these are very important issues for anyone of any age, but particularly those who may not be working, may not be in the workforce for as long, may be nearing retirement, or may have been relying on a spouse to financially support them. So oftentimes I will have clients that have no idea how much they need to live off of, or, haven't thought of all of those issues. So I will give them some things to do so that we can get some numbers. First, figuring out what their monthly expenses are. But if they're still living with their spouse post separation, they may have not have considered, can they buy a home, what the rent's going to be, what neighborhood they're going to live in. And so I spend a lot of time sort of working with them on those issues. The first thing, and I would recommend everyone do, is to do just a monthly financial statement of all the expenses your clients will anticipate having. And then for clients that I have had that just sometimes I represent clients that are the economically dependent spouse. And so they've never paid the bills in the household. They've never, as an adult, paid their bills. And now they're 55, 56, 57 for the first time having to make a budget and pay bills. I will refer them to a divorce financial planner, which will do more in-depth counseling of sort of setting up things for them and guiding them on what that transition looks like. One of the things for this population, this demographic, always make sure to include a consideration of health insurance, because post-divorce, they cannot maintain coverage on their spouse's employer-sponsored health plan. They are eligible for COBRA, but COBRA coverage is so expensive, it's really cost prohibitive. And so they really need to, one of the first things I do when I meet with someone is I have them really focus on the numbers. Do your financial statement and start shopping for health insurance. Go on the exchange, the health insurance exchange, and start looking for your options and figuring out what kind of insurance you're going to need and thinking about what your conditions are and the kind of comprehensive coverage you're going to need. And so if you are looking at calculating alimony, that number you need to include and ensure that the health insurance and medical care is included. The same is if there is any sort of chronic physical or mental condition that you are looking at, how often the client sees a physician or specialist. Do they travel for treatments? What are the costs for specialized treatments, medications, prescriptions? Because when you're doing your alimony request, you want to have all that money, you want to have all those expenses included and accounted for. And then one of the other issues that comes up often is trying to figure out if someone is really employable. So I've seen this come up in two different scenarios. One scenario is you may have a spouse who's not worked for decades and who's been out of the workforce, and they are concerned about what they can really realistically earn, or their position is they can't be self-sufficient. And the other spouse says, well, yeah, you just need to get a job. You can work. The other scenario is where you may have a high earning, economically empowered spouse in the relationship whose income is decreasing or is going to decrease post retirement. They're close to retirement just due to them slowing down, or not having the same sort of client base, or the same sort of workload or opportunities. And so you will have the other spouse say, well, you've been earning this amount and there's no reason you can't keep earning that amount moving forward. And so that's when vocational experts are very helpful to establish earning capacity. And earning capacity is really determining what can someone earn. And so these experts will meet with the client and interview them, look at their education, their training, their background, and also consider the market that you live in and really determine what can they potentially earn. And also giving consideration to their employment history, any sort of physical or mental health limitations they may have, and can come to court and really help provide the court with information that they may need to get a realistic assessment of what someone's earning capacity is. So always consider using those sorts of experts if you've got a complex issue around alimony and determining what an income is or should be. health decline, dementia, and divorce. I unfortunately have two cases this year that I'm dealing with this issue. In one of my cases, I had a client whose wife had a um, neurodegenerative disease, and she was diagnosed 10 years before the divorce. They'd been married 29 years, 28 years at the time of filing, had two adult daughters. One of the daughters had schizophrenia. The wife had a medical retirement, and the husband was the economically empowered spouse. And he had done a really good job with their saving and investing, and they had substantial assets. And so the wife just wanted 50-50 of everything. And my client didn't want the divorce, but the bigger issue was this was a woman who was really facing some neurodegenerative issues that were impacting cognitively her behavior, the reasons why she wanted a divorce. And there was a young man, I won't say paramour because we didn't establish a relationship, who was really encouraging her to file. And she was literally on a walker and he was driving her to the courthouse. And so the concern was, so you get this divorce and then what are you going to do? And so we were giving this woman $700,000 cash, plus there were other assets that were being transferred. And the idea was, well, what is she going to do with this money and who's going to safeguard it? And so, there was very little my client could have done. But one of the things that potentially they could have considered on the front end of that case was to when she got the diagnosis, was to think about doing a postmarital agreement and setting aside assets for her medical care, that both of them agreed that that would be the use of the money. And that was one way that we think in hindsight. But it's, when people are dealing with health decline and medical conditions, one of the things that, I've learned from experience that you can advise the clients to do is to really start looking early on at, what are the impacts? Like sometimes they understand physically what's going to happen, but they don't understand mentally that the way their spouse is behaving and thinking may change. In my other case that I currently have, I represent a wife and her 80-year-old husband filed for divorce, and he's alleging a lot of things, but that she's transgendered and promiscuous. It's all very confusing. And it's distorted thinking that we are certain are signs of dementia. The problem is the threshold for being competent is very low. And we had a emergency guardianship. We were able to get the court to grant that because of his delusional thinking and the fact that he had guns and was doing all these very unusual things. And they held him, and the hospital asked him, do you know the year? Do you know who the president is? And he knew all that. Do you know the date? Do you know your address? And he knows all those things, and he was released. We are proceeding with a competency hearing because we don't believe that he is able to competently participate in his representation, but it's a really close call. And so that's one of the things that I am seeing more often with this demographic. In another case, I had a client who was in his 60s. He was a anesthesiologist at a local hospital. I won't tell you which one. And he had a stroke. He did not inform the hospital. He was still going to work and putting people under and applying anesthesia. And he was reported by a colleague because physically he was appearing different. His face looked different. His leg was dragging. And so he appeared and speech was slurred. They were clear something went on. And during that case, it was questionable whether he was really in a position to be able to make decisions for himself. And his lawyer actually called me and asked me my opinion. I said, that's your client. And so, if you believe you're in a position where you need to advise the court and have a guardian appointed, you should do that. And so make sure you look at your ethical rules in your jurisdiction, because you do have an obligation if your client is in a position to direct you and competently participate in their case, that you advise the court. Survivorship. So many divorces, if they are resolved with them, there will be marital settlement agreements that will address issues of retirement accounts and quadros. But one of the things that is many, many times overlooked are survivor benefits. And so there are many times that I'm aware that it's relevant, but if I've got the economically empowered spouse and it isn't to their benefit to raise the issue, I don't tend to raise the issue. But when I have the economically dependent spouse, I always raise the issue of survivor benefits. And so there are two types of survivor benefits. There can be a pre-retirement survivor annuity, and then there is the survivor annuity that's paid after retirement. So if you do not have a survivor benefit, then your spouse is going to get your retirement, if you get it, as you get it, when you get it. And so what happens is, what the survivor annuity does is it says, even if you die, even if my spouse dies before he starts receiving retirement, I will still get a portion of that retirement. If my spouse dies after he receives retirement under the survivor annuity, I will still receive the retirement annuity. The reason that many spouses, the economically empowered spouse, doesn't want that is because, one, it costs more. It costs more, and it means that it's going to reduce the amount that they receive. But it's important when you're representing clients that you contact the plan manager, you understand what survivor benefit is available, what the cost is, and that when you are drafting a quadro, which is a qualified domestic relations order, that's the order that is required to actually have the money transferred as a part of the divorce, that you put in the survivor rights language. And so you should call the plan administrator and get their specific language, so that the language in your marital settlement agreement matches the language in the plan. And then the next issue is related to, and these are just sort of different issues that pop up that you can avoid. And one of those is the separation of non-probate assets. So if you go through probate and there's an estate, there's certain things that are going to follow whatever the will says. But there's some that don't pass through an estate administration. So that includes bank accounts, brokerage accounts, retirement accounts, life insurance policies. And so the issue arises when, one, they aren't properly or fully addressed in a settlement agreement, or when the spouse fails to change the beneficiary. So in Maryland, I pulled two cases that have this exact instance of where there was a full settlement agreement, but the settlement agreement lacked the language that specifically referred to the actual policy, and did not state that the spouse was waiving an interest, a specific waiver of interest in the account. So in the Cassidy case, there was a general waiver, but there wasn't a waiver that talked specifically about the life insurance policy, and that wife got the policy. In Maryland, in the estate of Bowdoin, this is a case that the estate brought against the wife. There were two wives, and there was a life insurance policy and an IRA, and the the spouse, the ex-spouse ended up being paid. And again, the court upheld the payout to her for both of those accounts because the beneficiary hadn't been changed and the language in the agreement was not specific enough to waive her interest. And the same exact thing happens in Carol S. East versus Payne Weber. So I will tell you that it's very likely that if you look in your jurisdiction, there are other cases, but I use cases from my jurisdictions that I practice in, you're going to see that issue show up across the country. So, my advice to clients, I tell them as soon as you can close joint accounts, even if the divorce isn't done, settle it. Open new accounts, retitle existing accounts. Sometimes parents, if there is a payout of child support or a payout of alimony, they'll want to keep a joint account open. I recommend against that. Always just start fresh with a clean account. Ensure your clients change their beneficiary designations and really stress that to them because sometimes as family practitioners, we don't do wills, we don't do estate planning. So we're not thinking, we're just thinking, let me get you this marital separation agreement done. Let me get you divorced and, my work is done. It's really, really important to give full effect to those agreements that while you're representing the client, that you encourage them. Did you get the beneficiary, change of beneficiary form? You see the form. You ensure that the language in your marital settlement agreements talk about beneficiary waivers specifically for whatever policy that you're including, and then follow up with them to ensure that the carrier, they actually did scan in email or upload the change of beneficiary form and that it actually gets processed because many, many times, too often, but not frequently, but many times you will have a divorce, but then you'll have issues in terms of assets and that don't agree when people think that they resolved the issues, but they just didn't tie up all of the ends. And my last advice is really think about use of postmarital agreements. Sometimes I represent clients that are on like their second or third marriage, and it's my experience that generally the breakdown is around issues, financial issues. They have adult children, they have a lot of assets, and there's some disagreement about we bought this and who's going to get it. Now, they may enjoy spending time together and companionship, but there's these financial disagreements that happen. And one of the ways to resolve that is a postmarital agreement. They can come up with an agreement while they're still married that addresses property division, and that agreement is going to be recognized as long as it's written and signed and notarized and fully executed. So try and rely on those. And sometimes I work with clients who don't necessarily want a divorce, but they're at an impasse on some sort of financial issue. And that's been a way that we've been able to resolve that issue. So this concludes my portion of the presentation, and I'm now going to turn over the floor to my colleague, Ms. Garner.
Thank you, Ms. Holloway. I'm going to share my screen. Can you all see my screen?
Yes.
Awesome. Okay. Good afternoon, everyone. So as Chandra and Marwan mentioned, my name is Keisha Garner. I'm the owner and managing member of Garner Law PLLC, located in Washington, D.C. And as Chandra mentioned, I do handle both family law and estate planning matters in D.C. and Maryland. And before I get into the presentation, I also want to mention that I'm also the current president-elect of the J. Franklin Bourne Bar Association, which is the NBA affiliate in Maryland. And we do have our president on the line, Emeka Onweze. And I also wanted to invite you all to our upcoming scholarship banquet, which will be on November 6th. If you're in the area, it'll be in College Park, Maryland. So at the end of the presentation, if you're interested, I can share additional information. So now back into the presentation. All right, so a lot of the things that, or some of the things that Chandra already mentioned I will touch on as well. So I won't belabor the point on what is a gray divorce. She thoroughly went through that. But definitely this is an area that's on the rise among couples over the age of 50. And the incidence of divorces in this demographic has doubled in recent decades. So what are the contributing factors? Again, why are the rates of divorce so high for those over 50? And a lot of times it happens because people are just growing apart after years of marriage. And, you know, women, we are doing big things and running the world, and we're no longer dependent on men to be the breadwinner. So that's another reason why gray divorce is on the rise. And then again, you know, sometimes people stay in marriages only for the kids, right? They may not be happy. They're staying in a marriage for the kids. And now that the kids are grown, they're out of the house, they're in college, these people are realizing that they're no longer compatible with each other. And so they also end up deciding to go get a divorce at that time. So what are the unique challenges of a gray divorce? So there are several. You know, when you're young, you haven't accumulated as much wealth, so you don't have much to divide. And as older couples, you know, you have accumulated more assets, including your retirement accounts, your real estate, and in addition to that, your life insurance. And so you may be closer to retirement or even already retired at that time. And that comes with a lot of things that you have to think about if you're deciding to get divorced. You now have more to lose in that separation. And then sometimes, you know, you may have a blended family, and you may have decided to include your spouse's children in your estate planning documents. Those children are not your biological children. So, you know, another unique challenge of a gray divorce is, you know, you need to decide, you know, who do you want to be your beneficiaries? Who do you want to leave part of your legacy to? And so why estate planning matters in gray divorces? You need to make sure that you're able to protect your assets for the beneficiaries that you intend to include. It's critical to understand, you know, how separation and divorce can affect estate planning, your financial security, and even your family legacy. And so when you're thinking about a gray divorce, you want to integrate your divorce proceedings with your estate planning updates. You want to make sure that you protect your assets from being inherited by unintended beneficiaries, such as your estranged spouse, their children, and you need to make sure that you make the necessary changes to your estate planning documents, your retirement accounts, your real estate titles, and your insurance beneficiaries. So all of these need to be, you know, whether or not you have a financial advisor, you have an estate planning attorney, you need to make sure all of your professional advisors are working together to ensure that your complete plan is working together to benefit what your intentions are. So when it comes to a will, right? Under the law, a spouse is your legal heir. So until you actually get a divorce, that spouse is going to inherit from you. Being separated is not enough. You actually have to be divorced. And if for some reason you die before your divorce is even finalized, your soon-to-be ex-spouse will inherit from you. In some states, once a divorce is finalized, the provisions related to that spouse in terms of what they can inherit is automatically revoked, right? So it's important to look at your individual jurisdiction, your specific jurisdiction, to see if that's the case in your jurisdiction. But even if you revoke what your spouse is going to inherit by virtue of having a divorce, it doesn't revoke all of the terms in that will, right? So there may still be some provisions that are still going to be intact. And that includes, you know, if you named your spouse as your personal representative, right? They are still going to be able to petition the court to be your personal representative as the person that you listed in your documents. And then in terms of a trust, unlike a will, the provisions concerning your ex-spouse are not automatically revoked upon the finalization of your divorce. So again, if you don't update your trust documents, your spouse will be able to, one, inherit what you left to them in that document. And also they may be able to be appointed as a trustee of your trust. And I'm not sure if you're getting a divorce, if you would actually want your ex-spouse handling all of your assets from your trust. So again, as I mentioned before, a divorce doesn't, I'm sorry, a divorce doesn't, a divorce separates you from your spouse inheriting from you. But what if you were separated and just never got around to actually filing the paperwork? Or what if you were in the process of filing and getting a divorce, but the divorce is not finalized and you pass away? What happens? Well, if you die before your divorce is finalized, then you're still technically married. And at that time, your spouse will inherit from you. And you are not able to, even if you're alive, you're not able to disinherit your spouse, right? And so the only way that you want to ensure that you don't have to pay out your spouse if you get divorced or you're separated, you want to make sure that you have what's a prenuptial or postnuptial agreement, because the laws allow for your spouse to have or be able to receive an elective share. That's what it's called. And depending on where you are, what your spouse can inherit changes. So for example, in Maryland, if you only have a spouse and there are no children involved, then your spouse received 100% of your estate. Okay. And I don't think that's something that if you don't have any children, that you want your spouse to receive 100% because you didn't update you didn't follow through with the divorce and make sure that that spouse is ultimately, by virtue of the divorce, disinherited. The other thing that must be updated are your powers of attorney and your advance directives. Do you want your ex making healthcare decisions for you during a medical crisis or your end of life or incapacity planning? If not, it's absolutely imperative that you need to review and update your estate planning documents immediately upon your separation and or divorce. Because again, leaving them named as your power of attorney will allow them to have access to, if it's a financial power of attorney, have access to your bank accounts and things of that nature. And again, if it's a healthcare power of attorney, allows that person to make life health decisions for you. And so immediately upon your divorce, you want to make sure that you sign a new financial power of attorney and also a new healthcare power of attorney. And a lot of times when we have the healthcare and the financial powers of attorney, we kind of keep them, we give them to who needs to have them. But you also want to make sure that you notify the different institutions just in case they have powers of attorney on file, because a lot of banks do, sometimes have you fill out their own individualized power of attorney at that branch or at that institution. And so you want to make sure you're notifying the institutions as well, so they keep an updated copy of who you have listed as your healthcare and financial power of attorneys. So divorce does not automatically change beneficiary designations on accounts, like a retirement account or a life insurance. Bank accounts are generally probate assets, but you do have the ability to place a designation on them, which is a pay on death or a transfer on death designation, which ultimately makes it a non-probatable asset, because at that point you pretty much added a beneficiary designation onto the bank account. And so if you have named your spouse as the beneficiary on your life insurance, your retirement account, any pay on death or transfer on death while you were married, and you don't update it after your divorce, your spouse will still inherit those funds, because financial institutions are generally bound to honor the most recent signed beneficiary form that they have on file after your death. And so you want to make sure that you promptly update all of your beneficiary designations to make sure that you have the intended heirs, because I'm sure your spouse will happily accept whatever proceeds they get from that insurance policy if you fail to do so. And the other thing to note is beneficiary designations always trump everything else. So if you have a beneficiary designation and you create a new will, and that new will is updated, you say, I want to leave my bank account to my sister Sam, right? But at the bank, you have your husband or wife still listed as a beneficiary designation. The beneficiary designation is going to trump what is in your will. So if you do not update your documentation in terms of who is listed as your beneficiary, who is listed there will get the funds, and whoever you have listed on your will not. And Chandra also spoke about the differences between what you could probably get, through Social Security benefits, and the importance of having quadros that are going to divide retirement benefits, after divorce. So I'm not going to belabor because you went through this already, but it's definitely very important to make sure that this gets done, and to also talk to your tax attorney regarding the different implications that can arise based on how you decide to, or what the assets are and the values are tax-wise, because there are certain assets that can get a step up in basis or have a carryover basis, which can definitely affect the taxes that you would have to pay. And when we are married, we also, most times own property together. And as you know, there are different ways in which property can be titled. Married couples, if you look at your deed, you would see something that says tenants by the entirety. So anyone looking at that deed would know that this property was owned by a married couple. Now, when you get a divorce, your deeds are not automatically updated, right? So it's very important to also get a new deed to retitle the jointly owned property to reflect whatever the new ownership is. And in divorce cases, one spouse can buy the other spouse out, or the house can be sold and the proceeds can be split. But as long as both names are still on the deed, excuse me, you are both still legal owners of the property, which means that you can't sell or refinance. Sometimes spouses get, divorced and they say the other person can have the house. I don't want anything to do with it. But then they don't do anything to retitle. And years can go by, and then by the time you want to do something with that property, the deed still says that it's owned by two people. And you would have to track down your spouse, and you may not even be on good terms, and do double deeds where you have to deed it back to yourself, but you have to get his consent because the deed has to be signed by both current owners. And so you don't want to have to deal with that tangled title mess. You want to make sure that, and that also can affect your estate plan, where, you're trying to leave the house to your children or some other heir, but now it's jointly owned by your spouse and you, because you didn't retitle the property. And that will affect how that house can be passed down to your heirs. So it's very important to retitle jointly owned property, get a new deed done, make sure it's recorded in land records. And then in addition to the retitling, if it's jointly owned in terms of a mortgage, you both share the mortgage or home equity loan, you want to also make sure that you do the work to remove yourself. Sorry. you want to make sure that you do the work to remove yourself from that mortgage or home equity, because anything that's not paid on that loan, any missed payments are going to negatively affect you if you both, remain on that loan. And you don't want to mess up your credit. So you want to make sure this is taken care of. And I think, as Chandra mentioned about long-term care, you may be covered under your spouse's plan. And after the divorce, that would eliminate the coverage that you had. And so you want to, do some research, evaluate any type of replacement options that may be available to you, and plan for new possible premiums in the event that you are going to lose coverage. And then you want to also reassess your Medicaid and long-term care eligibility after divorce. And there are a number of ways to plan for, long-term care. But the most important thing is you want to make sure that all the decisions that you're making have in mind that you're making it as a single person and not married, and that you will no longer have access to, the coverage that you may have currently. So the overall strategies to protect your assets in terms of estate planning after divorce is you want to make sure that you do a thorough review of all your assets and liabilities, do an inventory, keep track of what you have. And then you want to make sure you go through all of your documents to make sure that you see how things are titled after the divorce, to make sure that you change things that need to be changed. You update who your beneficiaries are, who your fiduciaries are. And it's very important, like I said, in terms of beneficiary designations, you want to make sure that those insurance policies are updated. So there are no issues with who is supposed to inherit, because they don't care what your intentions are. The banks and the insurance policies are only going to look to what name is on that beneficiary designation. And then in terms of any types of agreements that you can use in terms of strategies to protect your assets, you do want to look into, and I know Chandra mentioned this as well, pre and post-nuptial agreements. Because one of the things that you can do in a pre and post-nuptial agreement is you can waive the elective share. So I mentioned previously that you can't disinherit your spouse. And that's, the law is the law, you can't disinherit your spouse. But what you can do in a prenuptial agreement is that each party can waive elective shares. So in essence, that is disinheriting your spouse, but it can only be done through a pre or postnuptial agreement. And then also another thing that can be done with the pre-postnuptial agreement is the waiver of alimony as well. So what are the consequences of failing to do what we just discussed? So one of the consequences is you delay finalizing your spouse, and that can lead to challenges in financial obligations that remain in place. So you don't get divorced, or you stay separated, and then you die, and then your spouse who you intended to divorce ends up getting your entire all of your assets because you didn't divorce. So a lot of times older couples, they're tired. They don't want to go through the whole process. They want to, pretty much stay estranged and kind of live separately. But there is a consequence to that, right? You have to make sure that everything is legally put into place to make sure that the divorce is finalized. Otherwise, that not even an ex-spouse, but that the person that your estranged spouse will reap the benefits if you fail to finalize your divorce. Also, like I said, outdated beneficiary designations can harm you. And then, current people in your life that may expect to receive something after your death, they may be shocked. Even if you get remarried, your new spouse might be shocked, because if your old spouse is listed on your beneficiary designation, when it's time to and, marshal your assets and find out what's out there and see who's going to get paid out, there might be quite a shock to find out that your current spouse will not get your life insurance policy, and rather your former spouse, who you absolutely detest, will walk off with however many thousands or hundreds of thousands of dollars left in that policy. And your unwanted fiduciaries is also a consequence of failing to plan, because as I mentioned before, your financial and healthcare power of attorney, they have to be updated. And if not, whoever you leave as those designations in terms of a trustee, a power of attorney, all of those people will, and your spouse, if you list them as that in those roles, will maintain those roles. And I'm sure you probably don't want someone who you want to get divorced from to be able to make those decisions on your behalf if you're not able to. So so that is the conclusion of mine. But I also wanted to kind of, in terms of gray divorce, tell you an experience that I had recently, actually yesterday. I had a gray divorce is hard. And I recently had a case where the spouse, I represented the husband, somebody else represented the wife. The wife thought that she could just go into court and say, I want a divorce, and not have to divide up anything. So she showed up to court, and the the judge said, okay, you want to, have a trial or whatever. She said, no. She said, well, I want to go get an attorney, because I didn't know he was going to have an attorney, but I just want to get the divorce today, and I'll come back later to try to divide up anything else. And the judge says it doesn't work that way. So she thought she could just kick my client out of the house, get a divorce, and keep the house, right? But there are consequences, and there's marital property, and those things have to be divided. And so, when I explained that to her and her attorney, it at first it wasn't making sense to her. It's my house, I've lived there, I paid this, I paid that, but you have to divide it because it's marital property. So we went back and forth, back and forth, back and forth. And literally just yesterday, the two of them decided they're older, they can't start over. If they can't even afford to, even if they sold the house and split the proceeds, they cannot start over. So they're going to try to work it out. Okay, so the gray divorce is, it's very interesting, but that's another thing to consider. Most people don't have the ability to start over. And I think that's, so you might want to start planning for that. Nobody wants to get a divorce, but you might want to put that into your planning even before you get to the gray area of the gray divorce, so that you're be in a better position if you decide to get divorced later on, so that you're not stuck like these clients that we just had in court yesterday. So again, thank you. That was the end of my presentation. I thank you for your time. If you have any questions, I am here. Feel free to ask, and I will turn it over to Marwan.
Thank you, Keisha and Chandra, for providing us with that valuable information. Let's everybody give a virtual emoji hand of applause. You could put those little, emojis up on the screen. I don't know how y'all. There you go. I see them coming. That was awesome. I think that's how we're gonna give the hand of applause. From there you go. There you go. I like to see that. So we stepping it up into the digital era. Yeah, that was so great. You could see that there is a myriad of items that need to be considered when you are dealing with divorces, and you've acquired some assets, and if you want to protect your assets, you need to go to Keisha and Chandra. Otherwise, you're gonna have a problem. I didn't realize that it was that technical. And I guess the biggest thing that I took from that was I need to contact one of these smart individuals when I'm dealing with those issues. Hopefully, it's with a client who's coming to me, because that could be a mess. Well, I want to thank you all again. And that was just wonderful. It shows how many smart people we have within, our association and our division, who have a lot to offer. We've been doing a lot of collaborative, projects together. We're going to be doing more, and you can see why. And especially y'all with small firms, the game is changing a little bit. You see what Morgan and Morgan is doing, and I don't know if their business model is just PI, or if they do, engage in other practice areas. But for us to compete, we're going to have to collaborate and work together. And if we do, we will have more reach than a lot of people out there, because we are all over the country, and we have some very, very smart individuals who are a part of our association and division. So please be on the lookout for collaborative projects that we're going to be working on. Please remember one another when you have cases that come your way and they need to be, referred to a specialist. Let's keep it in house, if at all possible. We will be having our winter seminar in Antigua. Amanda, if you will share your screen and put it up, it has the dates on there. Please, you all, if you have the ability to attend, we need your attendance. We welcome your attendance, and this is a place where we have a great time with one another, and we continue to empower one another. So if you can make it, please make it. And if you want to speak on a topic, please reach out to Amanda, and let her know what topic you want to speak on. We want to do these at least every quarter. I would like to push for once a month, but at least every quarter we want to have a seminar, and make it quick, to the point, keep it moving. Everybody can get back to their day. But we definitely want to be more connected with one another. We've built such great relationships with one another, and we need that, monetize it. I'm really focusing on how we monetize these relationships with one another. We've thought about, and I've discussed with people, if we want to expand into different markets. If Keisha owns a McDonald's, and Chandra owns a Taco Bell, and I own a Burger King, okay, that's great, but there's no reason why we can't buy a Chick-fil-A together, okay, and go out into other markets and other jurisdictions and collaborate and generate cases and business. You all know, we got the expertise now. So a big part of this is about marketing and bringing in the business, whether traditionally, or digitally. So I've been talking to a lot of people about, hey, let's say we want to go into somewhere in Georgia or Florida. If we get 10 of us to put in 10 grand a piece to go into a market, that's $100,000. You could go and take a market pretty easily. I've done it for less. So please be on the lookout for the collaborative projects that we are working on. It may just be a campaign that we want to engage in, but we have the resources. We all have done, fairly well. And so now I want to help us expand and work with one another to continue to grow. So please be on the lookout for that. We're doing it. It's working. And we want to do it, some more, and spread it to everybody. We're also going to be pushing the NBA small firm case referral pipeline. That's really out there to send cases through small firms, and we will make sure that those cases get to the individuals in the city, state, and who specialize in that area of practice. So we're really gonna be pushing that as well. So with all that said, thank you so much. I won't hold you any longer. Keisha and Chandra's contact information is in the chat. Please reach out to them if you need any help with those specialty areas that they just discussed, and be on the lookout for the next seminar. Thank you all. Have a wonderful rest
And
of your
Marwan, can
day.
I just say one last
Sure,
thing?
absolutely.
Chandra did put information about the Bourne Scholarship Banquet in the chat. So if you are interested, there's a link that has information about the tickets, where to purchase tickets. And I hope to see many of you there if you're in the area.
We all, Keisha, I, and Emeka all want to see you there. I'm the immediate past president. I'm over scholarships this year. We want to raise as much money as we can for lost students. So please support us if you can.
Absolutely, absolutely. Yeah, let's support one another and donate whatever whatever you could afford. Doesn't have to be a crazy amount, but I'm sure everything will help. So let's support each other. And with that said, Amanda, is there anything else?
That's it. Great job, everybody.
Thank you, Amanda, for
Except for
organizing
let me thank Amanda.
everything.
I really just show up. I really just show up on the Zoom. Amanda really coordinates all of this. So thank you, Amanda,
Yes, thank you.
for putting this together.
Thank you,
Okay.
No problem.
All right.
Amanda.
Save
All
the
right.
date,
Thanks,
guys. We
guys.
have another one
Thank you.
coming up on
Have a good
When's the
day,
next?
tentatively.
everyone.
When's the
Never
next
mind. I was just
one?
gonna say
Wednesday,
tentatively
Amanda,
we
she's
have a
on.
save the date. I'm sorry, can y'all hear me? I was saying tentatively save the date for 11/11 for our next seminar. I'll be sending out stuff soon.
Okay. Thank you, Amanda.
Thank you.
Thank you,
Thank you.
Marwan. Great to see everyone. Thank you,
All right.
guys. Have a good day.
Bye.
Likewise. Talk to you. Bye.